All right. Welcome, everyone. Good afternoon. My name is Michael Moreland, and I am the director of the McCullen Center here at Villanova University's Charles Widger School of Law. The McCullen Center seeks to bring a true diversity of views here to Villanova and provide a distinctive space for faculty and students across the university to discuss issues related to constitutional liberty, especially freedom of speech and religion, the place of religion, society, and civil discourse on challenging topics. Just in the past year, our guests have included former South Carolina Governor Nikki Haley, constitutional scholar Akhil Amar from Yale, and Archbishop Boris Gudziak, the Ukrainian Catholic primate of the United States. A little preview of coming attractions. Already for next semester, we have a couple events scheduled. So if you are on our email list, you'll get notice. If you'd like to be on our email list, you can let Melanie Dudley or me know. In February, we will host Judge Chad Riedler of the U.S. Court of Appeals for the Sixth Circuit and Lee DeJulius, the managing partner of Jones Day's New York office, for an event. And in March, we will host Judge Kyle Duncan of the U.S. Court of Appeals for the Fifth Circuit. One of the signature programs of the McCullen Center is its annual sponsorship of the annual Donald A. Giannella Memorial Lecture, one of the most distinguished programs in law and religion anywhere in the United States. It's sort of the Nobel Prize for law and religion, if you will. Professor Giannella taught here at Villanova from 1960 to 1974 and was indisputably one of the leading scholars of law and religion, indeed a pioneer in the field. Through the generosity of Professor Giannella's family, colleagues, Villanova Law alumni, and other friends, an endowed fund was established to honor him through this lectureship. Recent lectures have included Michael McConnell of Stanford, Anthony Kronman of Yale, Sarah Barringer-Gordon of Penn, Leon Cass of Chicago, and Indisar Rab of Harvard. And we are delighted this year to welcome Helen Alvaré to those ranks. Thank you to the many people who have helped to bring about this event: Melanie Dudley, the Assistant Director and Program Manager of the McCullen Center, Ethan Dewar in Law School Communications, and the many administrative support, development, IT facilities, and communication staff at Villanova who have been so generous in their assistance. Thank you also to the members of the McCullen Center Advisory Board who are here. Helen Alvaré is the Robert A. Levy Endowed Chair in Law and Liberty at George Mason University Antonin Scalia Law School, where she teaches family law, law and religion, and property law. She publishes on matters concerning marriage, parenting, non-marital households, and the First Amendment religion clauses. She is faculty advisor to the Law School Civil Rights Journal and the Latino Law Student Association. She is a member of the Holy See's Dicastery for Laity, Family, and Life, a board member of Catholic Relief Services, a member of the executive committee of the AALS Section on Law and Religion, and an ABC News consultant. She cooperates with the permanent observer mission of the Holy See to the United Nations as a speaker and delegate to various UN conferences concerning women and the family. In addition to her books and her publications and law reviews and other academic journals, Professor Alvaré publishes regularly in news outlets including the New York Times, the Washington Post, the Huffington Post, and CNN.com. She also speaks at academic and professional conferences in the United States, Europe, Latin America, and Australia. Prior to joining the faculty of Scalia Law, Professor Alvaré taught at the Columbus School of Law at the Catholic University of America, represented the U.S. Conference of Catholic Bishops before legislative bodies, academic audiences, and the media, and was a litigation attorney for the Philadelphia law firm of Stradley, Ronon, Stevens, and Young. She received her JD from Cornell University Law School, an MA in theology from the Catholic University of America, and most importantly, her bachelor's degree in economics from Villanova. In fact, I would have to do research to confirm this. I believe Professor Alvaré is the first Villanova alumnus ever to give this lecture. Welcome.
Hello, everybody. I am very grateful to be here and grateful that you are here, especially having graduated Villanova in 1981. I married a fellow graduate on this campus in 1985. My father graduated here in 1948. He came over from Cuba, and Villanova was where he attended. And this place was very important in my faith formation and in my life. So I'm honored to be back here. And of course, I also want to thank the McCullen Center and the Giannella family, which reminds me we just don't have enough Italians in DC, and it's always good to be back under the auspices of one, and my talented colleague in this field, Professor Michael Moreland. So when I received this invitation, I realized the universe was telling me that I should finally make time to explore a question that had bothered me for years, but was so laborious to investigate and frankly controversial that I was really stiff-arming the universe. So it concerns a common difficulty that especially Catholics and other Christians face when they're charged with discriminating against persons under employment or public accommodations non-discrimination laws. They insist rather, though, that they're only refusing to cooperate with another's conduct. I'm going to be concentrating especially on the Catholic dilemma on this. It's a dilemma for other religions, but because of my knowledge and this venue. The most common cases raising this dilemma involve marital status or sexual orientation non-discrimination. A religious believer or an institution will refuse, for example, to do something like house or employ a person in a cohabiting relationship. It's an unusual number of these cases, or refuse to assist celebrating a same-sex wedding. Again, the Catholic employer or vendor or landlord replies to the non-discrimination charge, no, I'm not discriminating on the basis of a protected status. I regularly employ or serve or house people of every marital status and sexual orientation. I'm simply following a religious belief to avoid cooperating in conduct that violates my beliefs. Or if I'm an institution, I'm hiring for mission, because after all, everyone knows personnel is policy. But courts engage regularly in a practice that I'm going to call for short conflating. They conflate status and conduct. They equate a refusal to cooperate with another's behavior with illegal status discrimination against him or her. Courts say the conduct of cohabiting or same-sex marrying is simply too closely correlated or intrinsically related to the status of being single or being gay. Or they say, and this was Justice Ginsburg in the Christian Legal Society case, it's too laborious for us or for the state institution to separate out whether a person is engaging in status discrimination or really just refusing to cooperate with conduct. Or the courts say, it's unbelievable that people would make these kinds of distinctions. We just don't believe it. Now, let me say preliminarily that it's absolutely necessary in any non-discrimination lawsuit for a court to closely examine whether any defendant, including a self-described religious defendant, is, well, lying. We call this a pretextual reason for their behavior. So, for example, when Bob Jones University claimed, as it did in 1983, that it wasn't discriminating against Black persons, only against the conduct of interracial unions, it was perfectly right that the Supreme Court said that's a pretext. I don't care how Bob Jones dresses up its position, you are acting on a wrong belief about racial inferiority. But pretext hunting is not what's going on in the cases that we're going to look at together today. In fact, these cases inevitably involve defendants who have a record of hiring, serving, housing people of every marital status and sexual orientation. And the opinions conflating status and conduct aren't reporting the typical pretext findings. For example, that the defendants were caught saying awful things about members of the protected class, or they were happy enough to employ or serve or house a person in an openly adulterous relationship, but not in a cohabiting relationship. These are the typical kind of pretext inquiries. No, these courts, on a close read, are presuming the insincerity or the implausibility or just the outright untruth of a believer's assertions that they can welcome persons but not cooperate with a particular conduct. And furthermore, these cases wholesale ignore religious institutions' need to hire for mission. But I'm going to argue three things about the practice of conflating today. First, that it's extremely injurious to religious believers, personally, socially, legally, even spiritually. Second, that it is not grounded in the text of the relevant statutes or in the Supreme Court precedents they inevitably rely upon to do it. In fact, for those of you who are law students, a technique that I realize that I follow in a lot of cases is to, you look at support or precedent for something, and then you look at it really closely. And then you look at the fact that over the years, courts are just using string cites of these same quotes from these same opinions. And then you go look at the case and you go, it didn't do that. And you unpack what was actually happening. It's extremely laborious, but a very valuable, close scrutiny of cases. And then finally, I'm going to argue that the practice of conflating poses significant free exercise problems. So first, to the harm caused to believers. Catholics believe that their religious tradition forbids the stance they're accused of taking, and instead requires welcome and respect for every person. This set of beliefs is long-standing and foundational for Christians, going back to the first book of the Bible's instruction that we are made in God's image and likeness, and thus possessed of an inalienable dignity and worth. And then, of course, to Jesus' command in the New Testament to love your neighbor. Who's your neighbor? Anyone strewn in your path. To love your neighbor as yourself. Differences between persons must be overcome by their origins, their common origins and common destiny in Christ. As in St. Paul's admonition, there is neither Jew nor Greek, male nor female, slave nor free, but all are one in Christ Jesus. Catholics also believe that special attention is owed to the vulnerable. Remember Jesus' kind of scary warning regarding the Last Judgment and those who did not see him in the hungry, the ill, the stranger, the outcast. I can tell you my formation here in campus ministry was really big in that. I was married, my husband and I, by the director of campus ministry, who was the head of all these fabulous social justice programs on this campus. This teaching about human equality and the necessity of universal respect is also specified in the Catechism, interestingly, concerning the very protected classes these cases consider, the single and the same-sex attracted. Regarding the former, the Catechism states that single persons are quote, especially close to Jesus' heart, and, quote, deserve special affection and the active solicitude of the Church. The great family of the Church must be open to them all. Regarding the latter, the Catechism is likewise insistent upon an attitude of genuinely loving welcome, saying every sign of unjust discrimination must be avoided. There are also important theological principles undergirding Catholics' inability, however, to cooperate with others' conduct, including others' sexual choices. These principles include the whole array of Catholic teaching about sex, marriage, and parenting, and the religious injunction against cooperating with the conduct of others that contravene your beliefs, okay? Whether cooperating takes the form, and here if you look at the Catechism and other theological sources, whether it takes the form of establishing a procedure, protocol, or contractual agreement by which the conduct will take place, or advising it, or seeming to approve it, all of which might be even further problematic by becoming a, quote, scandal, the word meaning stumbling block, for onlookers' proper understanding of the faith. At a moment in history when people are accustomed to referring to their identity very often as largely captured by a sexual identity and choices, people are offended when onlookers decline to affirm the identity or cooperate in it. Many people, including judges, therefore find this set of Catholic teachings nearly impossible to digest. They believe that refusing to approve or cooperate with another's act is tantamount to rejecting persons, and doing so on deeply hurtful, discriminatory basis. But of course, in Christianity, the essence of human identity is first and foremost as a beloved child of God, made in his image, made to know and love him and one another, while being, of course, as fallen woman and man, constantly prey to original sin. But we are never in Christian theology reduced to our traits or acts. And of course, Pope Francis is the living, breathing exemplar of this theology. He regularly and warmly reaches out to the young and the single, empathizing with the difficulties the world has thrown in their way. Excuse me. While also at the same time exhorting them to reject what he calls liquid love, the culture of the temporary, which he includes cohabitation as part of. And no pope has done more to invite those who identify as LGBTQ into the Catholic community, while simultaneously affirming the Catholic understanding of marriage, in Francis's words, as an exclusive, stable, and indissoluble union of a man and a woman open to procreation. And thinking for a moment about the teachings associated with Catholic institutions declining to cooperate in another's conduct, these institutions are attending to the fact that they're nothing less than ecclesiastical. They're church institutions. They are not, in the words of Pope Francis in his very first homily, just another NGO, a non-governmental organization. But rather, they are first, communities of people responding to the call of Christ to perform a particular service and transmit the faith. Second, communities called to manifest what Christ promised us, that he would not leave us orphan. How will people know that? Through our being Christ to others. And third, communities called to provide a glimpse of the inbreaking of the kingdom of God in the world until he comes again, right? The early fathers of the church comment on the best possible view people could have of Christians. See how those Christians love and love one another. So this is true of every kind of Catholic institution: education, social services, healthcare. Regarding education, Vatican II's Declaration on Catholic Education calls Jesus the divine founder of Catholic schools, which pursue his mandate of proclaiming the mystery of salvation to all, forming students to be conformed in their personal lives according to the new human being created in justice and truth. Pope Francis's Education Office has further written that schools' ecclesial dimension should penetrate every moment of their educational activity, constituting the essential element of their identity. On the matter of Catholic social services, Pope Benedict's, my favorite encyclical, God is Love, Deus Caritas Est, speaks of Catholic social services as, again, just in the echoing of Pope Francis here, not as just another kind of welfare activity that could equally well be left to others, but as indispensable to the Church as word and sacrament. On the matter of hiring for mission, he's written elsewhere, the Catholic social services should select their personnel from among those who share or at least respect the Catholic identity of their works and give an example of Christian life. Finally, respecting Catholic hospitals, Pope Francis's Pontifical Council on Healthcare refers to the services of every person at a Catholic hospital as meant to express, quote, love of neighbor, when performed in fidelity to the moral law that constitutes both fidelity to the human person and a simultaneous expression of the wisdom of God. So against the backdrop of these teachings, which I've just laid out a whole lot of stuff as the backdrop, but it's the theological grounding that I need to get into the law. Against this backdrop, when courts conflate the status of a person with his or her conduct, think about it. This is what they're saying. They are legally declaring believers bigots. And at the very same time, by the identical statement, saying that the believer has, in the eyes of the court, done what her religion forbids. That is, discriminated against a fellow human being on the grounds of a personal trait or condition. And not just any trait or condition, but traits and conditions that the Catechism teaches ought to provoke particular solicitude. And we should remember that it's also very likely, once the believer has been found to discriminate, has been found guilty of status discrimination under the law, she will be legally required either to do what her religion forbids her from doing or close her business. In short, conflating is very destructive to religious belief. Now let me turn to my second part, how courts' decisions to conflate are problematic from a textual and legislative history context. And fascinatingly, this was the part that was the biggest revelation to me preparing for this, not at all supported by the language in the Supreme Court decisions that they all cite. There's just this string cite in the cases again and again. And you go look at it and you go, oh my gosh, it doesn't do that, okay? So, as I've already noted, courts are conflating status and conduct, most notably in cases involving cohabitation and same-sex union. Those are the most that you find at the state level and a few at the federal court level. It's mostly state because we're dealing with a lot of state non-discrimination laws, right? And they're finding discrimination in relationship to some states' laws banning marital status non-discrimination and sexual orientation non-discrimination. You know, this precise language is not in federal laws, but it's in a lot of state laws. Now, even considered from a purely textual and legislative history basis, conflating is really a problem. The statutes themselves clearly state that discrimination is forbidden based upon a person's status, not based upon their conduct. And they say nothing about forcing anybody, believer, nobody, to cooperate with the conduct of another person. If you actually look at the legislative history of these statutes, by marital status, they really meant being single versus being married, being widowed or divorced. The origins of these laws, if you do a nice deep dive into the legislative history, these got started in the 1970s, when despite women's newly empowered state, right, we were getting more education, we were getting more jobs, we were being heavily discriminated against in the credit market in particular, and we were struggling to get leases and mortgages. And marital status non-discrimination laws came in. You know, they had the general language to cover all marital statuses, but they had in mind of the legislators women who were single or widowed or divorced, okay? Likewise, sexual orientation non-discrimination laws ban discrimination on the grounds of a person's being homosexual or being heterosexual, et cetera, based on their sexual orientation, okay? So about 5 states' courts in cohabitation cases have rejected conflating status and conduct. They say pretty straightforwardly, the statutes just don't bear it out. They say no discrimination based on a status. Furthermore, and interestingly in cohabitation cases, they note additionally that would be sort of nonsensical for a judge to interpret a non-discrimination law to protect the conduct of cohabitation when, in fact, some of these states still had bans on it. There are still laws about bans on cohabitation, very few left, but they exist. But the laws in their jurisdiction, even if they didn't ban it, they clearly favored marriage over cohabitation. So I teach family law, and there's only a couple of jurisdictions in the United States that provide remedies for cohabitants. Otherwise, all the remedies are for married folks, and cohabitants are treated more as legal strangers who haven't yet entered into that contract. But several jurisdictions do conflate status and conduct in cases involving cohabitation or same-sex weddings, and they regularly rely on a bevy of Supreme Court opinions to do so. So now I'm going to march you through these opinions where I discovered so much of interest on this question and show you why courts relying on them to conflate are mistaken. So summarily in advance, let me tell you the major mistakes they make, and then as I go through them, you can spot them. First, conflating courts are claiming that Supreme Court opinions rendered holdings that they actually didn't rend. Those were not the holdings of the cases. Second, conflating cases involve the question of private individuals declining to cooperate with another's conduct. But the Supreme Court cases they cite as precedent regularly involve state action banning or even criminalizing another's conduct. So Lawrence versus Texas, a ban on same-sex sexual relations. Obergefell, state law saying we're not going to recognize same-sex marriage. In cases where the state has something to say, your conduct is criminal, we are not going to recognize this relationship, you'll see the court made the statement, we think this statement from the state has an effect on what people believe about the status of other people. But what if you're not the state speaking or criminalizing somebody's conduct? You're a private person who says, I'm declining to cooperate, not a state criminalizing or banning your behavior. Fascinating disconnect between those. Additionally, conflating cases are failing to apply the one and only Supreme Court opinion with extended guidelines for distinguishing status discrimination from opposition to conduct. There is a case, it's very clear. It was argued by and won by attorney John Roberts before he went on the court, and it's called Bray versus Alexandria Women's Clinic. And finally, conflating cases have yet to consider the Supreme Court's language in a 2023 case, 303 Creative, where the court strongly suggested that a refusal to cooperate with conduct is simply distinct from status discrimination. So now let me go through these. I begin with Bob Jones University, the earliest Supreme Court opinion relied upon by conflating cases. There, the court upheld the IRS's decision to strip that university's nonprofit tax privileges. In light of the school's policy that all races could enroll, but they could not support or engage in interracial dating or marriage. The school argued that it was not engaging in unfavorable treatment on the basis of a person's status as Black, but only objecting to conduct, romantic affiliation. The Supreme Court subjected Bob Jones' claim to pretext scrutiny and said, your policy clearly grows out of status animus. It is clearly about a misguided belief about the inferiority of one race to another. And then I should add that every single case that the Bob Jones Court cited in support of its pretext finding was a case that found actual status discrimination regularly underlying a pretextual reason. But conflating cases ignore Bob Jones's pretext analysis. Thus, its ultimate finding was there was actual status discrimination, not a refusal to align itself with conduct. They cite Bob Jones instead for the proposition that all opposition to any romantic affiliation equals hatred of the status of people who enter it. Therefore, opposition to cohabitation means you don't like single people. Opposition to same-sex weddings means you don't like people who identify as homosexual, okay? But this is not what Bob Jones did. Chronologically, the next case to consider conflating was Bray versus Alexandria Women's Clinic. Like Bob Jones, this is a case in which the court examined whether opposition to conduct, abortion, because you had abortion protesters, was no more than a pretext for status discrimination against women. Again, Bray is the only Supreme Court opinion that gives us guidelines for teasing apart opposition to conduct from status discrimination. In Bray, an abortion clinic claimed that abortion protesters inevitably have a problem with women. Their animus is really against women. But the court rejected this claim, noting and admitting only women get abortions, we get it, but it applied what it called a rationality test. The court said, quote, some activities may be such an irrational object of disfavor that if they are targeted, and if they also happen to be engaged in exclusively or predominantly by a particular class of people, an intent to disfavor the class can be presumed. And then the money line. A tax on wearing yarmulkes is a tax on Jews. Okay? So they said, clearly, it's so irrational to have a tax on yarmulkes that we see that as a pretext for anti-Semitism. Okay? But then, applying this case to the case of opposition to the conduct of abortion, the court said opposition to abortion is not an irrational object of disfavor, but there are, in its words, common and respectable reasons for opposing it, including to protect unborn life. Also, it noted, well, women are on both sides of the issue. How could this be animus against women? And it said both federal and state law regularly favor birth over abortion, for example, in the allocation of public funds. In sum, the Bray court concluded, opposition to abortion is in no way a pretext for opposition to women. But conflating cases misuse Bray in two ways. First, they regularly only cite that phrase, a tax on yarmulkes is a tax on Jews, suggesting falsely that Bray always counseled conflating where you have conduct closely associated with a protected class. They cite that constantly and nothing else from Bray. Two, they completely ignore Bray's rationality test. They ignore that the court applied the test precisely to a situation in which only members of the protected class engaged in the conduct and yet found no status discrimination. If you applied the Bray test to these cases of cohabitation and same-sex wedding, people protesting that conduct would survive a pretext analysis, right? Regarding cohabitation, in addition to, I have a religious view and it's longstanding in my church, blah, blah, that a defendant might say, you also have the empirical data today, more empirical data than we've had before, of cohabitation's association with higher rates of divorce, domestic violence, and it's a big location of non-marital births. No state welcomes it in law as they welcome marriage. And recent Pew surveys show you've got single people on both sides of the idea as to whether cohabitation is a good thing for them or for the society. Regarding the source of opposition to same-sex weddings, the summary, all the leading histories on this subject show that the leading reason for the opposition was to allow the state to privilege a vehicle, opposite-sex marriage, that allowed children to know and be known by the parents who brought them into this world. I teach family law, and I have a very funny time convincing my students after the Obergefell decision that the state actually isn't invested in your romance. What it really wanted by giving you the benefits of marriage was for you to stay together and take care of those kids. It wanted to have a future society, and it wanted you to have the privileges of staying together to take care of them. The state is far less interested in you as your romantic attachment than it is in making sure you pay for those kids out of private funds versus state funds, right? And that was the leading rational reason given for opposition. And of course, the Supreme Court itself, in Justice Kennedy's Obergefell majority opinion, referred to objections to the conduct of same-sex weddings as, quote, decent and honorable, reasonable, and sincere. And 34 states had laws to that effect before federal courts began striking them down. So again, if you apply bit by bit the Bray analysis, it would survive a pretext analysis, these oppositions to conduct in the cases I'm describing. Chronologically, the next Supreme Court case opining that opposition to conduct affects status discrimination is Lawrence v. Texas. There, the court struck down Texas's ban on homosexual relations, saying, when homosexual conduct is made criminal by the state, that declaration is an invitation to subject homosexual persons to discrimination. It said, we're not dealing with mere disapproval of conduct, but a criminal offense with all that that imports for the persons charged, a criminal record, registration as a sex offender, having to note this on future housing or job forms. But conflating cases regularly cite Lawrence without noting that they are cases not involving state action, not criminalizing anything with all of the correlative problems that are associated with that, but rather private persons declining to cooperate with conduct. And I could illustrate many cases on this, happy to do so in further details, but for reasons of time, won't go through with that. After Lawrence, the next Supreme Court opinion to conflate status and conduct is the Christian Legal Society versus Martinez case. The Christian Legal Society at UC Hastings said that its membership was limited to those who shared its belief that, quote, sexual activity should not occur outside marriage between a man and a woman, and who would seek to repent when they felt short. So they excluded both heterosexual and homosexual persons who did not agree with this mission, okay? Hastings refused to register them, saying you have particular discrimination against the class of persons who are homosexual. But CLS has no precedential force on the matter of conflating. First, the court wrongly claimed that CLS only opposed, quote, unrepentant homosexual conduct, when in fact the group standard applied to all sexual orientation. Second, CLS court acknowledged there might be a difference between status and conduct, but it was too laborious to require a state institution to tease it out. So they used their discretion to avoid that. Next, in its 2015 opinion asserting a constitutional right to same-sex marriage, Obergefell, the Supreme Court likened a state's denial of same-sex marriage to status discrimination, saying such denials disrespect and demean homosexuals. It referenced Lawrence and said, just like a criminal law that makes these people criminals, we do not want to make persons who identify as homosexual against the law in this area of marriage. So one additional Supreme Court case discussing the status conduct problem should be mentioned here, though it's so new that other courts haven't applied it yet. It's the 303 Creative case involving a free speech claim by a woman who said Colorado is likely to enforce a sexual orientation non-discrimination law against me. I am religious. I simply cannot draft wedding websites for same-sex weddings. The court distinguished status and conduct pretty straightforwardly here, saying, quote, she refuses, the state insists, because she objects to the protected characteristics of certain customers. But the party stipulations speak differently. They agree that she will gladly create custom graphics and websites for gay, lesbian, and bisexual clients or for organizations they run, but not for any person who asks her to do things that violate her beliefs. While this observation wasn't a necessary part of the court's holding, it's kind of stunning and clear, and the first time since Bray the court has spoken so directly. In short, courts' decisions to conflate status and conduct not only defy the text and legislative histories of the statutes they're applying, but wrongly rely upon Supreme Court language to do it. But now to my final point. I think, and usually we get to the question of religious believers' free exercise after they've already been charged with discrimination, and they say, okay, and they're put in a very difficult position, I want a get-out-of-jail-free card. You've called me a bigot, so now I'm legally a bigot, but I want a right to persist in my bigotry because I have a free exercise right. I am seeking to avoid that outcome. I am seeking to bring a religious freedom analysis right up to the first step of the litigation, where you ask the question, have they even violated the statute? Okay? I think there's 3 violations of free exercise that happen in conflating. First, courts end up evaluating the plausibility and accuracy of religious beliefs, contrary to a long line of Supreme Court cases saying this is none of judges' businesses. Second, courts are interfering with the religious institution's authority over internal management decisions, contrary to the church autonomy doctrine. And third, by conflating, courts are systematically and quite predictably treating religious classes of persons lesser than non-religious. So, on the first point, the Supreme Court has forbidden courts from adjudicating the plausibility or truth of theological matters. But courts conflating status and conduct consistently flout this when they conclude that conduct that's closely correlated with a protected class, that objecting to that conduct really can't be other than status discrimination. There is a really long line of important cases. Ballard in 1944, Thomas Review Board, this is one of the most central case. It was a Jehovah's Witness denied unemployment compensation for leaving work without good cause. He had quit a job making tank turrets, even though he had previously had a job in the rolling foundry making sheet steel, some of which was used for weapons. And there was another guy, a Jehovah's Witness at the factory, who said, making tank turrets does not violate our religion. But the Supreme Court held that a court's resolution of what is religious could not turn upon a judicial perception of the belief or practice in question. Instead, there could be interfaith differences, and the belief need not be, quote, acceptable, logical, consistent, or comprehensible to others, unquote. Although it can't be, quote, utterly bizarre or completely non-religious, okay? So this holding and this exact language has been repeated in the Hobby Lobby decision in 2013. And of course, in the decision you had a big one here in Philadelphia, Fulton versus City of Philadelphia, to the same effect in a case concerning the free exercise rights of a Catholic social services agency in declining to certify same-sex couples for foster parents. But courts conflating status and conduct regularly transgress this clear Supreme Court doctrine. They conclude that conflating is necessary because non-marital cohabitation or same-sex weddings are simply closely correlated to certain protected classes. So in the Masterpiece Cake Shop decision, the court simply concluded, ipsy dixit, that the baker's beliefs that he could serve particular individuals but not celebrate a same-sex wedding could not possibly be rational. There was a Richardson case involving a Christian college in the Northwest They had a cohabiting employee. This became public. She had contracted to abide by the school's teachings on this matter, but she sued them when they let her go for marital status discrimination and won. The court presumed that because more single people than married adulterers cohabit without marriage, okay? So more single people than married adulterers, right? So cohabit without marriage, because the school could not rationally avoid status discrimination unless they continued to employ a teacher who had violated her contract and was opposed to their mission. A second free exercise problem is the trampling of church autonomy, okay? The Supreme Court in Our Lady of Guadalupe case in 2020, most recently, has forbidden courts from, quote, interfering with a religious institution's authority over its internal management decisions essential to its mission, okay? But courts conflating status and conduct in cases involving a religious institution's employment decisions about openly dissenting employees, they're denying these institutions' right to direct their internal operations, specifically to pursue their mission through hiring people who role model and transmit the institution's beliefs. In fact, courts conflating in the context of a religious institution are not only transgressing church autonomy, but they are, as a matter of law, denigrating hiring for mission by equating it with violating the Christian love command. For when a court legally concludes that an institution is discriminating based upon a person's marital status or sexual orientation, even though they hire all kinds of marital status and sexual orientations, a court is doing nothing less than declaring the institution in violation of Christianity's command to regard every person as equally in God's image and worthy of respect. Such a judicial determination is clearly at odds with the Our Lady of Guadalupe church autonomy pronouncements, that religious institutions have a right, quote, to decide for themselves, free from state interference, matters of church government as well as those of faith and doctrine. Importantly, in Guadalupe, the church stressed that an institution's right to hire its own ministers, the personnel who communicate its faith, was but one component of a broader church autonomy doctrine. And Guadalupe banned the states from interfering even, let alone dictating such matters. I should briefly note here that hiring for mission is not just a Catholic or even any religious institution thing. There is a venerable literature. One of the best summaries of it is Cass Sunstein's book, Conformity, called the Social Influence Literature. And it demonstrates that no matter what the institution, in order to preserve its mission, it needs a majority or at least some critical, influential mass of knowledgeable, confident, expert, relatable individuals who speak in favor of and role model the desired beliefs and norms. And individuals who do the opposite of this lose their mission, okay? There's another copious body of literature about how this maps on to religious institutions, okay? But it's reasonable what they're saying here. It's not just a Catholic prescription with doctrine behind it. It's also what every institution sort of knows. A final religious freedom problem. When courts conflate status and conduct, they predictably and systematically disadvantage the class of religious persons as compared with the classes of non-religious persons. The Free Exercise Clause forbids the state from systematically treating non-religious groups better than religious groups. While the court's Employment Division versus Smith opinion declared that neutral laws of general applicability burdening religion need only survive a rational basis test, the court's later opinions in the Fulton case, and also in Tandem versus Newsom, you remember the hair salons and nail salons can meet, but churches can't, sort of case that came to the Supreme Court out of California. These opinions established, respectively, that the existence of governmental discretion regarding the application of a policy, or the government's treating of comparable secular activity better than a religious activity, render a policy not generally applicable, and therefore subject to strict scrutiny. Courts, who are state actors, courts choosing to conflate status and conduct, however, are consistently and predictably treating the religious class of persons worse. To wit, a court's choice to conflate status and conduct, again, immediately constitutes a judicial declaration that the believer is a bigot as a matter of law. And remember, there's additional harm to believers here because at the very same time, it's a declaration that they are hypocrites within their own religious tradition, discriminating against a fellow human being on the grounds of a personal trait or condition. This amounts to more harm than non-religious classes would suffer should a court decide not to conflate. In this event, the member of the non-religious class loses the ability to force a religious person or institution to cooperate in their conduct, but contrary to, and remember, they always have the opportunity to use a pretext analysis. If someone is really discriminating against them based on their status, go for it, sue, win. There's discrimination there. They always have that vehicle. Also, unlike the member of the religious class, however, the non-religious classes are not legally declared a bigot for opposing the beliefs or conduct of others. And they're not instructed by a court of law that they violated their own deeply held norms about how to treat fellow human beings. Courts choosing to conflate are clearly exercising discretion to do this too, of the kind that Fulton and Tandon said makes a law subject to strict scrutiny. None of the texts of the non-discrimination laws at issue in any of the cases I considered say that status discrimination equals opposition to conduct. Conflating courts deliberate whether to conflate them. And they even admit that they're making a call and they're not sure which way it could go. In the 10th Circuit's 303 creative case, the court literally said it could go either way. In the Richardson case about the teacher at the Christian college, the court said, hey, the text of the non-discrimination law is, quote, ambiguous and susceptible to both parties' interpretations, okay? When courts conflate, they usually say they're attempting to ensure that non-discrimination laws avoid demeaning members of protected classes. You go back and look at the history of civil rights laws, this was a big factor, right? But if that's the governmental interest they're pursuing, their actions predictably demean members of religious groups more than non-religious. For again, upon conflating, religious members are declared bigots, declared hypocrites, and usually required to cooperate in conduct they judge to be immoral, none of which is happening to non-religious classes. So to my brief conclusion, I'm pretty much on time. There is no doubt that non-discrimination laws are not just a social good, they're a social excellence and should be enforced according to their text. They take care of the people that our history as a country has identified as needing special solicitude to prevent their marginalization or worse. Courts should scrutinize asserted reasons for people's conduct, refusing to hire, serve, or employ another person. They should scrutinize them to determine if the reason is no more than a lie, a pretext for discrimination against a class of persons. But they shouldn't systematically marginalize religious believers in the process. It is not only legally wrong, but deeply offensive to believers. And there are broader negative ramifications as well. By conflating, courts are marginalizing people in society who understand themselves religiously bound to respect human beings across their diversity. This is a socially valuable group of people, especially in an increasingly irrational and polarized world. These are people who try to hold themselves accountable to being sensitive to the value of every human life. But courts are suggesting also by conflating another ramification, that especially on issues of sex, marriage, and parenting, extremely controverted in the United States today, that the state will have the first and the last word in contests with believers. And I would just ask you at some point, and I've written on this elsewhere, look at the data on what believers are promoting. Believers' ideas are socially valuable, okay? Empirical data, for instance, robustly attests to what Christian tradition has held forward, especially on the matter of, stable marriages, stable marital parenting, et cetera. These are not the people you want to silence at this time in history. And finally, with every case in which a believer's declining to cooperate with conduct is equated with status discrimination, there is not only a further erosion of religious freedom, but the bald suggestion that religious freedom is itself tantamount to bigotry. I think only people who have enjoyed the benefit of religious freedom for so long could be cavalier about its value and the vigilance it takes to preserve it, but we shouldn't be. Thank you very much.
A few minutes for questions until 5 o'clock, and then we do have a reception just around the corner in the student lounge for those who are able to stay. But for now, we'll open the floor to any questions, including from the Con Law 2 students whose minds should be at work right now.
Yeah. I'll start with you in the front, and let me just call you out any few hands in a row so I can get us over. Okay, we'll just start with you. Right. You never know.
You mentioned 303 create
Yeah.
and 10th Circuit's discussion of religion.
Yeah.
Yet the Supreme Court only granted cert on the free speech issue.
Right.
Comment on why you think they didn't take the opportunity to decide the case on religious.
Yeah, I don't know the answer to that. The question of speech, I know regarding the litigation strategy of groups like the Alliance Defending Freedom, who represented the website designer in that. In my view, I think some of these groups think the speech argument is the slam dunk, that the precedential strength of not coercing speech is very, very strong. Whereas the straight out question, like the one they didn't answer in Masterpiece Cake and the one they didn't take in 303 Creative, does the state have a compelling state interest in requiring religious objectors to cooperate with behavior? I think they think maybe that's a harder case. I think a lot of people do. It's because the whole area of, I can't remember who used the expression that I'm stealing now, nailing Jell-O to a tree. But the idea of what is a compelling state interest for students in Professor Moreland's class, what's a compelling state interest? And just to give you an example of the potential range of that, you remember the Hobby Lobby case. So Hobby Lobby, for those who aren't as familiar with it, you have closely held corporations who do not wish to cooperate. They believe in contraception. They just don't believe in certain forms of it that act after an embryo is formed. This violates their pro-life feeling about not destroying embryos. We go all the way to the Supreme Court on it. And by the time they get to the Supreme Court, most cases below, the government's been winning. And they win on these claims about compelling state interest in forcing employers to provide, including religious employers, to provide contraception in healthcare. At one point, the government is actually winning in lower court cases on the idea that it's not only important to have employers provide it, but it's important to have them provide it in a seamless way, in a certain kind of policy that's linked in a certain way with their insurance company. And it's sort of like, really? Is that compelling? Like, we're used to thinking of a compelling state interest to squash racism, a compelling state interest, to squash other kinds of discrimination. The idea of a compelling interest to force someone to cooperate with conduct, you only get there, and that's what I was attempting to explore here, if you've already got people who are found guilty of status discrimination. I think we could stop this train at that part of the litigation. And again, I think it puts religious folks in a terrible place when they are now, by the time they're making their free exercise claim, in front of a court that has called them bigots. It also means, and I think it's Nathan Chapman has written about this, another scholar in our field, once they have said, I don't believe that you religious types can draw a line between status and conduct, you really don't like the people you're discriminating against here. Once you doubt their sincerity there, doesn't that undermine their ultimate case to say, I have a sincere religious belief and therefore you should let me have my free exercise here? I think there's all kinds of links between those levels of the litigation, those moments in it that are concerning. Thank you. That's a question. I wish I knew all of it. Okay, also in the back, yes. Yeah. Yes. Yes.
So it's not really static.
No, it's not at all. So just for those who didn't hear all that, so yes, the Religious Freedom Restoration Act, students of Professor Moreland, you already know that it was meant to restore a stronger protection to religious freedom, which had been reduced from sort of an always strict scrutiny analysis if there was a substantial burden on religion to, well, if the state has a rational reason for this neutral, generally applicable law, let them have it. If religious people are burdened, too bad. Religious Freedom Restoration Act comes in, reestablishes a strict scrutiny standard, but then in a case, the Bernie case, this court says it only applies to federal laws. So all these different state laws, which are tons of them, do not get, the state itself gets to decide the level of scrutiny that will apply when even a neutral law burdens free exercise. We certainly have at this time, obviously a more religion protective Supreme Court, sometimes through the Religious Freedom Restoration Act, sometimes through, often it's interesting how much they marry the establishment and the free exercise clause in some cases. I think the Lutheran Preschool, Carson v. Macon, and Guadalupe were all both, yes, if I'm recalling that correctly. So it's protective, but they still, as to this first question, have not taken the nub of this question as to whether the state has a compelling state interest to force the vendors, the landlords, and the employers of this world to do what they believe would be a violation of their own religious beliefs. And so I don't know that we know the answer to that yet. And I'm trying to do it at a very mundane level of the state non-discrimination laws, but I am trying to bring in a federal question. I really do see free exercise problems that make the question of violation of a state non-discrimination law a federal question of free exercise early on. I don't think it's a stretch. I've read these cases so closely, and their lack of believing that a religious person might draw this line shines through clear. They really think we're implausible. But for a religious believer, and I don't know if I'm just speaking for myself and others, the idea, think about what we say to our children or to a friend who's making, it doesn't have to be in the context I'm talking about today. I love you. I just can't help you with this decision. I can't support that. Okay, I just can't do that. But please believe me that I am here for you, that et cetera. It's very painful to people who want to draw those lines to be told those are implausible and you're nothing but a bigot. And that, who knows what inspires a law review article, but I have to say that was part of the inspiration for my writing this, is realizing how painful this is to people who are really trying to do what I said Pope Francis is the exemplar of, and what our theology and the Catholic tradition indicates ought to be done. Okay, I'm going to start with students. So let me take those two students, and then that's probably going to be the last question, but I'll be happy to chat with you. Yes? Rightly so.
How do we distinguish between those who practice religious beliefs and those who may use religious beliefs to justify their own beliefs and to discriminate them?
Great question. Let me tell you that courts end up having to do this all the time in employment and public accommodations non-discrimination cases. We have tools from outside the religious conscientious objection arena that can help us. And what I'm saying is, if you go and you read some literature on civil rights laws and people putting forth a rationale, I didn't hire you because of this, or I fired you because of that, there are lots of pretext investigations. Did you treat people who were similarly situated different? Did you treat this one in a way that clearly indicates discrimination? Did your rationale change over time? Were you shifty for the reason you did such and such a thing? Did we catch you in some outright nasty statement about members of the protected class? So we have had the tools for drawing this line. And not to get all meta on you here, but part of what you're pointing out is how hard it is for judges to do so many things. We've already talked about how hard it is for judges to do that old nailing Jell-O to a tree thing of what is a compelling state interest. And I'm also telling you, This is not, and we're not going to be happy in every case. But it's not as if courts do not have some practice in doing this. Question behind you.
Hi. So earlier in the talk, you mentioned how the Supreme Court decided to iterate the marriage cases, identified people that discriminated against interracial couples for using the conduct of the marriage as a pretext for the status.
Exactly, yeah.
And so my question is if religious institutions deny services to gay married couples because of the conduct of gay marriage, how are we able to make that legal distinction between punishing gay marriage versus on the pretext of conduct versus status? Because in my experience is talking to gay family members and persons of our community, the ability to legally be recognized as having equal relations under the law as heterosexual people is central to fighting for gay rights. So how can we
Right.
make that distinction between status and conduct for one group but not for the other?
So I'm actually not saying that. I'm saying you should look for status discrimination for every group. You always should see if that's what you can find, because that's what the law prohibits, number one. Number two, we need to be clear about where conscientious objection refusals are coming into. It's not in providing services to gay couples. That happens all the time. It's in doing a wedding is the usual place. So it's much more limited than you think, okay? And the pretext analysis is available regarding any protected category of people. Going back to the question prior to it, that if it really is about, I mean, that's not going to stop people who are not receiving the service. I'm not going to decorate the cake for that wedding, or I'm not, whatever the religious objector says. That's not going to stop them from feeling offended. It's not. The question is whether that is enough to conflate, especially considered the offense that's also on the other side as well. So I guess, I know we're out of time, but very simply, we do have tools for determining pretext. It should apply regarding all protected classes. No difference between race or national origin or sex or sexual orientation or any of that. But I do know that we're not going to stop people in this wide society from feeling offended that other people don't want to cooperate with their conduct. Whether it's a question of a wedding or who you're living with or any other conduct you might have that someone might not wish to agree with or support. It's not a peaceful question. It can be if the people involved are mutually respectful. But I do draw the line very clearly between status discrimination and requiring to be cooperating with conduct. Thank you very much for those good questions, and I appreciate it.
Thank you very much, Professor Alvaré, for that thoughtful presentation. So again, we have a reception just around the corner in the student lounge for those who can stay and would like to continue the conversation. If you have CLE forms, you can drop them off here at the table. Thank you for coming, and we look forward to seeing you at another event soon.